Okay, good evening, everyone. We'd like to welcome you all to the Clarion County Marcellus Impact Fee public meeting here at the Main Street Center. I think we were hoping for a little bigger turnout than this, but everyone who's here should be commended for showing an interest in the county and the community. My name is Wayne Brocious, Clarion County Commissioner. I'd like to introduce you to everybody here at the front table in case you don't know. Immediately to my right is Commissioner Butch Campbell and Commissioner Greg Fowler. And we have Doug Hill from Harrisburg joining us tonight. He is from the CCAP organization. For those of you who don't know what that is the County Commissioners Association of Pennsylvania. And he's studied the law a lot more in detail probably than we have. So he agreed to come up and help us out tonight in case there's any questions that anybody has that we're not sure about. So we appreciate Doug for coming up tonight. And all he got out of it was a free dinner. So, okay, we'd like to go over a few rules for the meeting here tonight. First of all, I did want to mention that this meeting was not required for us to do. This was just something that we as the commissioners decided that we would do to try to get feedback from the public and you folks. And I see we have some supervisors here and other people from the community, and that is great. And again, this is to talk about the fee, the impact fee, and that's kind of what we want to keep it at. We don't want to talk about, drilling in general and whether that's a good thing or a bad thing, and we want to keep the gas companies out and all this and that. We're here to talk about the impact fee alone, questions and comments, and if you want to express an opinion as to whether you think we should enact the impact fee. That is what we're here to discuss tonight. If you want to speak, stand up, identify yourself, and maybe tell where you're from if you want to do that. And we have a microphone over here to your right. You can use that. You don't have to use that if you don't want to. But if we can't hear you, we may ask you to step up to the microphone. But with the small crowd I think we have here tonight, we may not need that. Again, all comments should be related to the legislation and the ordinance that may be passed or may not be passed. And each person or group, if you're representing a group, would be limited to a comment period of 3 minutes because we want to keep this meeting, within parameters in a decent time. We don't want to go home at midnight tonight, as I'm sure you don't. So, with that, did everybody sign in? We did have a sign-up sheet going around, and we do appreciate that. And I also wanted to mention that we are recording the meeting tonight on tape, and we will be taking minutes with Angie Keller, our chief clerk over here, who I see is typing away right now. So, thanks for being here, Angie. Okay, we wanted to start with our guest of honor down there at the end, Doug Hill. He's going to go over some general points on the impact fee and some things how this came about and the purpose of it. And Doug, I believe, was in the negotiations as the bill was being drawn up. So he has a lot of insight on that. Doug, go ahead.
Thank you. Now, I'll stand up. That'll make it a little easier to focus a little bit on what I'm talking about here. And first, let me commend the commissioners for holding this session tonight. As they indicated, this is not required, but the more information we get out to the public on the act, its purpose, and how it's going to impact the industry here locally, I think better. As was indicated, I am Executive Director of the County Commissioners Association of Pennsylvania. We are a nonprofit, nonpartisan association. We do legislative and regulatory representation, training, insurance, research, technology, and other services on behalf of all the Commonwealth's 67 counties, and we're based in Harrisburg. As was indicated, I was part of the group negotiating what ultimately became Act 13, and my role was to represent the interests of the counties and their constituents. Overall, let me just give a few points overall about the statute and then focus in a little bit more on the impact fee, because that's the primary subject of the meeting tonight. Under Pennsylvania law, for years, oil and gas extraction has been regulated. We had what was called, oddly enough, the Oil and Gas Act. The problem was when Marcellus technology came in, the law did not deal adequately with some of the unique aspects of that industry. Certainly didn't envision an industry where you were pulling a couple hundred trucks of water and gravel and sand into a site. Some of the other unique aspects of running laterals rather than vertical drilling and all those kinds of things. And so the Pennsylvania law on its face needed updated. In addition, what we were all seeing and what you're now seeing is the impacts of that unique drilling operation. And that includes companies coming into town from out of state, that includes major work crews, that includes the trucks, the traffic, it includes a run on the courthouse and the recorder of deeds office, because every one of those properties has to have a complete deed search to know who has the right to the extraction of the gas. So there are a broad array of impacts that we were seeing from this industry. None of that was addressed in prior law, and so that's been the subject of negotiation for the last few years and ultimately ended up in the adoption of Act 13. The law does three primary things. First, it establishes an impact fee and defines how it's going to be used. Second, it deals with the entirety of environmental issues relating to the technology and extraction. And then third, it deals with how the degree to which and how local governments can regulate the drilling, the land use aspects of the drilling. And so I'll briefly mention the last two. Insofar as environmental regulation, almost all of that falls with the Department of Environmental Protection. And that includes permitting, that includes water extraction, that includes wastewater issues, it includes presumptions on pollution, site reclamation, and a number of other things. And all that falls under DEP's purview. The last section relates to municipal zoning. And the issue there, quite frankly, was one that the industry was running up against a myriad of different statutes from municipality to municipality, some attempts to outright prohibit the industry from coming in, and a whole list of other things. And so the intent of the General Assembly was to provide uniformity statewide. It does not take away zoning power per se, but it does limit it in a very specific way on what you can and can't do relative to things like access, setbacks, and some of those kinds of things. So it allows local regulation, but it establishes very strict limits on how that's to be done. So those two areas, if you really need to, we can get into questions, but tonight the real focus is on the impact fee. The impact fee is given to the counties to enact, and that's really the entirety of the county's role in putting it in place. We simply do an enactment. It's by ordinance. It has to be advertised at least 7 days in advance, and then voted by the commissioners. No hearings required, nothing other than the advertisement, and then the final vote. Once it's adopted, the county notifies the Public Utility Commission, because they're the agency then that will administer the fee. The PUC in turn will send bills out to all the companies based on the wells that they have. They collect the fee, and then they disperse it as provided for under the Act. The disbursements go in a number of different directions, but they are all addressing different aspects of the impact of the industry. So there are several funds, state funds, where money's taken off the top. Conservation districts, a small amount to Department of Transportation, some money to the Pennsylvania Emergency Management Agency, money to the PUC for administrative costs, and some environmental money to some specific programs. After that's taken off the top, then 60% comes back to the local level, the impacted county and its municipalities. And there's a very specific distribution formula. A part goes to the county, a part goes to the host municipalities, and another part goes to all of the municipalities, host and non-host. And that's all on a formula basis. The Act provides how that money's to be used. It's a broad set of 13 categories, but it really touches the whole array of potential impacts, whether that's infrastructure, highways, bridges. It can include judicial costs. For example, counties have had to add additional court time because of litigation over the leases. It can include addressing other environmental issues that you might want to address. Can go for human services, and the list is a good bit lengthier. So, and we can talk about that more if you'd like. Municipal share, same thing, same set of allowable uses. Again, a broad array to use how you see fit locally. The only requirement is that you do an annual report to the state and on how those funds are used. The other 40% that's left goes to the state, and that's divided up among a specific list of programs, and that includes environmental, transportation, water, and a number of others. And so it is really diverse. It addresses a number of specific impacts. In the transportation piece, that is a fund that is actually split up among all the counties in the state. So in addition to the host county money, Clarion would also receive money from that, and that's to be used for at-risk bridges. There's also a piece that comes back to all counties in the state, and that's to be used for environmental programs, recreation programs, open space preservation, and those kinds of things. So there is an additional piece that comes back from that as well. So overall, what it is trying to do is address that set of impacts. Excuse me. The PUC is the administrative body, and they will be doing the collections annually. For the first year, it's based on the wells that were in place in 2011. The bills will go out in September. The money's due into the PUC 1st September, and then the distribution goes out to all the funds by December 1st. In subsequent years, the payment is due by the 1st of April, and the distribution will be by the 1st of July. The PUC, as I say, has the entirety of administrative responsibility for the fund. So they will do the billing, they will do the collection, they will do the enforcement, they will do the audits of the companies to assure that they've paid the proper fee. The fee itself is a per well fee. So it's a flat fee per well, and the definition is they use is a spud well, and spud simply means drilling has started. So if drilling starts, then that well counts for the fee. The fee is payable initially whether the well produces or not. And the whole point of that being, we've seen a lot of circumstances where the company will put in a well, but because they don't have lines run yet, or because they're just trying to do it to secure the title to the well, if they haven't started drilling, if you don't know, within 5 years of executing the lease, then the lease expires, they have to renegotiate. So they'll often just drill the well, cap it, and then they've proven the lease, and so they're set at that rate on the lease going forward. Bottom line is the fee will still come in whether or not it's producing for the first 3 years. If it has not begun producing after 3 years, the fee is suspended and then picks up again once it reaches a certain production level. For each of the wells, the fee is paid over a span of 15 years, and it's a declining fee schedule. So the first year they pay the most, and then it declines over time, and then after 15 years the fee's gone. That well doesn't pay anymore. However, if they re-stimulate the well, if they do additional laterals out of the same well, or if they put another well on the same pad site, that starts the clock again. That's counted as a new well, and the fee starts again. The fee itself is adjusted annually based on the price of gas for the prior year. So for the payment that will be made in 2012, it's based on the average price in 2011, which was in the $4 range, and so it's going to be $50,000 per well that was sunk last year. This year, we're anticipating the fee's going to be a little bit lower because the average price right now is in the $2, $2.50 range. So the fee will be a little bit lower, not half, but it'll be a little bit lower. And it'll be adjusted each year based on gas prices, but it's also adjusted in the other direction as well. It's adjusted going into the future based on cost of living, so the whole schedule gets adjusted that way. So that's the briefest rundown, and I don't know if the other commissioners are going to be saying a few words.
Can I just
And
have
then-
a clarification on a couple of points?
Sure, or do we want to do the remaining comments and then take questions?
Tell you what, I'm gonna go to Greg for a moment, and then we're gonna open it up to questions, okay? Greg is gonna talk a little bit about impacts on Clarion County if the ordinance is enacted. Correct?
Well, kind of correct. I really want to just stress to you a little bit of information I've achieved from GIS and planning with Clarion County. This is something that's here. And we have right now, depending on different townships, this is from DEP. We have 112 sites that have been permitted. Now, permit doesn't mean that they've actually been spud or that they'll ever will be, that these are DEP's list. Porter Township is a big one, in Toby Township, if you're familiar. 28 in Toby Township, 29 in Porter. Those are the two biggest ones. But just so we have an idea, I didn't do a count of just how many townships there are. Right now on this list there's 11. So that leaves a lot that don't have anything even permitted. I know in my own township, Washington Township, up around 208 and 36, there's some active site preparation going on there, and it doesn't even show up on this list. So I don't know, when I saw that, there could be discrepancies on DEP's list to what the PUC would have. The other thing I wanted to stress to you in this meeting was, again, this is coming from DEP, pulled down by our GIS department. There are 16 wells on a list that was achieved from the DEP site. Toby, Porter, Limestone, Madison, Ashland, Elk, Knox. So these are ones that we know from the DEP site that are actually spud wells. So, give you a relation of their 16 versus 112 that we can pull down. Now, you can also go to the PUC site and achieve a list also. And we just came from a 3-day conference in Harrisburg. I didn't have time today to go on to the PUC site, but our word from that site says that we have 14, and when we go on to DEP, there's 16. So we'll be checking that discrepancy out and make sure why this site has 2 more than what is on the PUC site. So I will have this information if anyone later would like to look at it. I didn't have a chance to print more copies off, but this is available. Like I say, this information came from DEP. If you are interested in what the effect of a well site, and these are pictures I have from, again, GIS on a well site development in the county. If anyone wants to see, I do have aerial photography of what a well site in Clarion County is going to look like. Some of them, this one might be, this one's actually one in Ashland. Some of them are fully developed. This one is developed pad site without a well. Some of them are in various degrees of stages of development and activity. And I thought it was very informative and very enlightening if anyone wants to look at those also. So that's what this meeting is about. It's about providing information both ways, being more informed both from you as a public, and I thank you for coming tonight. And I hope we can provide information that you didn't know, and you can ask questions, and we can learn also something that we didn't think of. And in that respect, that's why we have Doug here, and he did an excellent opening, and I'll turn the meeting on over to Wayne. Thank you very much.
Okay, thank you, Greg. I'll get to Mick's question here in just a minute. I did want to say, if the county does not enact the impact fee, of course, we can be overridden by municipalities in the county. I think everybody probably knows this. More than 50% of the municipalities, or municipalities that represent more than 50% of the population of the county, they would have 60 days after our 60-day period to enact if we don't. And our 60 days is 60 days from April 14th. I think the actual date is April 16th, correct? Because of the weekend. So we have till April the 16th to enact that if we're going to. And we do plan on taking a vote on April 11th. So that's why we want to have this meeting before that. Mick, did you want to ask a couple questions?
Yeah, if I could, Mick Robertson from Lakeview Township. I just wanted to clarify with Mr. Hill a couple of points. The well fee is per well pad site, regardless of how many laterals are drilled, or is it per lateral that fee is assessed?
It's actually per borehole.
Per borehole.
So it doesn't matter how many laterals go out, unless they put additional laterals later, and then that counts as a new fee.
It doesn't matter how many laterals go out.
Correct.
So if there's a well pad site that has 8 laterals going in 2 different directions on it, that's one $50,000 fee that is assessed.
If one borehole is...
Per borehole. So there's 8
Right.
$50,000 fees assessed per that well pad site.
If you have 8 boreholes.
Correct.
Yes.
If you have 8 laterals going out, there are...
No, laterals different from the borehole. The typical borehole would be single hole down, and then when they get to the bottom, it'll be 6 to 10 laterals. That's typical.
My
if they go
understanding of
horizontal.
how this drilling is done is that they do distinct separate sites, because you can't go down the same borehole and go in 2 different directions.
Right. That's correct.
It's a single borehole with multiple laterals.
No,
Okay, no, okay.
I don't believe so.
So a well pad site that has 8 laterals going out of it, which you're saying would be a single borehole, would be one $50,000 fee assessed. Is that correct?
If there's a single borehole, yes. If there are multiple boreholes, it's per borehole.
So it makes no difference how many laterals are going out from that well?
If I'm misunderstanding the technology, forgive me. My understanding was there could be multiple laterals from a single borehole. But we'll get that clarified, and I'll send
Okay.
a note up to the commission.
The other question I had was about counties that don't have any drilling activity done. Do they still need to enact this ordinance to be eligible to receive other monies that are going through the 40% that the state gets?
They do not.
They do not need to enact the ordinance.
That's correct.
If a county that is in a drilling area does not enact the ordinance, but the municipalities do by resolution implement the fee in the county, does the county still receive the fees
No.
that would be coming to them?
The county still has to act. The county's prohibited. Actually, what happens is 2 things. First, the county doesn't receive its share of the 60%, but then the county's also prohibited from receiving its share of the other state money out of the 40% until it takes its own action.
So counties that don't have drilling activity do not have to enact the ordinance and are still eligible to receive from that 40%, but counties within the drilling activity that don't enact the ordinance are not eligible to receive that 40%.
If they don't act, that's correct.
That's inconsistent.
Well,
I mean, is that compliant with the state constitution?
yes.
That would be my first
The issue is this. The enactment means that the enactment is by impacted counties. And there is a distinct amount of money that goes to them that's not available to the counties outside the area. So they get that differential by their enactment.
Right, but they would still be eligible, if the counties do not enact the ordinance, they would still be eligible to receive the fees that non-impacted counties would receive.
They're not.
They are not.
They're not. And
So there is a
that's,
difference.
that you might say is a legislative incentive for the county to do the enactment, in part. But in the first instance, the county has its opportunity to get the impact fees to address the direct impacts that the county's seeing based on the activity.
Okay, yeah, I just wanted to clarify this. Thank you.
Sure.
Okay, thank you, Mick. Ron?
I had a question. If
Could
PUC,
you state your name?
sure, Ron Wilshire, Clarion, if the PUC is playing such a major role in terms of billing and collecting the money, why does the county even have to adopt the ordinance?
That was the strategy the legislature adopted to give a local option and not have it be a single enactment at the state level.
And just one other question. Since the PUC is playing such a major role, are there any situations where eminent domain can be claimed by the gas industry?
Eminent domain is not addressed in the act.
Okay. Is that no then?
That's correct.
Okay.
No.
Okay.
There is a provision in the Act that calls on the state to ultimately address pipeline issues, pipeline placement issues, but they are not addressed in the Act right now.
Thank you.
Anyone else out there have a question or a comment?
Susan Honfeld, Mill Creek Township. Tagging Mick on what you said, I guess my concern is if we've got a township that has not subscribed to this, and we have a borehole well pad, and we have all the horizontals going out, there's a huge probability that those horizontals can actually go into municipalities and townships and they'd be impacted
Well, that's
underneath the ground.
That's actually a moot issue. If the county acts, the municipalities don't have to do an enactment. The only time municipalities would need to do an enactment is if the county refuses within its 60 days to enact. And then for this year only, as was stated, they have the option to take a vote locally to force the fee to be levied. And that passes only if either half of the governing bodies of half of the municipalities or the governing bodies representing municipalities with half the population of the county enact it. If that happens, if it goes that route, then the only municipalities, the only municipalities that receive any part of the funds are the ones that have enacted. So if you hit the threshold and you're a municipality that hasn't taken action one way or the other, it's probably in your best interest to go ahead and enact it as well so that you also receive a share of the distribution. But it is based on the location of the wellhead. It has no bearing on where the laterals run. Now, in the distribution formula, the 27% share that goes to host and non-host municipalities, that particular share has a formula that's weighted toward hosts plus municipalities that either abut a host or are within 5 miles of a well pad. So it does extend out some and take into account the impacts regionally.
All right. I know there's a number of individuals in this room that, and the nasty word was not mentioned whatsoever, and that was water. We're talking about impact fees in general. My concern with Act 13 and impact is there was no assessment done, whether per county, whether per municipality, township. There was no impact study done, whether industrial or environmental. I don't recall a conversation that any of our commissioners had, at least in my township, with respect to if my neighbor decided to lease, which is their right, the impact on my environment, on my property, has never been addressed.
This isn't a question in this law about impact personally. It's about the fee that we're going to get because of the impact. The huge difference there, Susan, about how your neighbor impacts you, as opposed to whether or not you're going, your municipality and your
My
county.
roads are going to be fixed. Let's talk about impact. My roads are going to be damaged and then fixed.
Part of the fee, and it covers
Right.
that.
But why is water not being addressed?
No.
That's my question.
It's not addressed by the county, and it's not addressed by the county fee. It's actually a separate section of the law that falls under DEP purview, and it includes a number of different components. It includes extraction of water for fracking uses. It includes disposal of the water from fracking, It also has requirements for water testing, pre and post development, and it sets a rebuttable presumption on who's responsible for pollution if it's found. And it also requires the industry, if the particular producer, if they're the ones responsible, it requires them to provide an alternate water supply. So that water is addressed, it's just not addressed at the county level.
Do you want to talk?
Does anybody else have it? Lady in the back. Your name, please.
Elizabeth Fuller, Clarion County. Since you have all said that you don't have to do this, you don't have to be here, you don't have to ask us our opinion, and you are going to vote on this in 2 weeks, what are you voting on? What are you going to do?
We have not decided yet.
Well, what are you talking about doing? Is it a secret?
Yeah, we have not decided. That's why we're holding the meeting. If we'd already decided whether we're going to implement the fee or not implement the fee, there's no sense in having the meeting. We're here to get information from the citizens to help us make an informed decision, either for this impact fee or not for it.
Well, what are your positions on it? I mean, have you discussed it? Have you thought of
My-
any possibilities? Are you going to reject? Are you thinking about rejecting the whole process, or are you going to participate? Are you
We are, at this point, I personally am thinking both ways. I've been reading on it, I've been going to seminars on it, I've been going to breakout sessions on it, and I've gone both ways on it. Today, if you ask me how I'm going to vote, I honestly have not made a decision yet. And that's why I'm here listening to you, so that I can help make a better informed decision.
I just don't understand what the whole purpose is if you don't have to do this.
We don't have to have the meeting,
Yeah.
but we want to,
Yeah.
because we want the impact and the input from the citizens. This Board of Commissioners is interested in hearing what you have to.
For your interest. But I really would like to hear some of your ideas and thoughts and how they will affect us. Personally, I'm saying go for the impact fee, take everything you can get, because we're going to need it down the road.
Okay, that's what we wanted to hear.
Okay?
We want to know what your opinion is,
There's my opinion.
and we thank you for that. But I personally, I've been kind of like Butch. I was leaning one way first, kind of lean another way now, and then we brought this idea up of having a meeting, and we're like, well, I'm not going to decide until after that. And I've met with different township supervisors. They seem to be overwhelmingly in favor of the impact fee. Okay, who was next? The lady back there beside her.
I'm looking for the lady.
You're the lady. Your name.
To the extent that percentages...
Your name, please.
Your name.
Jane Shouts, Farmington Township. To the extent that percentages have been allocated as to being distributed in due process, exactly what discussion has already occurred about the default of that reimbursement? To what extent is there coverage for roads, bridges, water, pollution, whatever, that is not addressed by the money that is returned? Who accounts for the overage of expenses?
Well, that would be up to the municipalities to decide.
Yeah, let me answer that a little bit of a different way. Prior to the law, there was no reimbursement of any kind required from the industry. And we've had, in the history of the development of Marcellus and Utica and the other formations, some of the industry step forward, they give money locally, but it's all ad hoc and it's all precisely what they feel like giving, and they can withdraw it at any time. The law puts in place a specific fee that they are to pay, and it reimburses it on a specific formula, so there's no gamesmanship out of Harrisburg. It's a specific formula that will go back to the county, its host municipalities, and the other municipalities in the county, and it's intended to address the impacts. you're right, it may or may not address all the impacts, but at least it gets something direct from the industry back local. Now, the other question that we get is then what happens to, in the cases where the industry has been voluntarily giving money. And typically where we've seen that is that the industry will come in and pave the roads in the vicinity of the well site. I can't speak for your industry, your particular producers up here, because I've not talked to them. But by and large, the producers that we've talked to have said this fee, the fee that's levied by this statute, is not onerous enough to make them stop doing those other voluntary contributions. It's also, let's say, a matter of enlightened self-interest, because they also want the road into the well pad paved so that they can get the trucks in and out more quickly without breaking axles. It's good for business for them to pave the road. So we anticipate that in most circumstances they will still be doing that. The other point, and this is particularly for the township supervisors in the audience, the law specifically says the vehicle code provisions still remain in effect and still apply to the industry. And what that means for the township is you can still bond the roads, you can still execute what are called excess maintenance agreements. So, if you have overweight limit trucks and those kinds of things, you can have an agreement that they are actually going to be assessed specifically for the damage to those roads. And so that'll still continue. And then last, the industry still has an interest in being a good community citizen. So most of them have budgets to do the contributions to Little League and some of the other things that they've been doing. So, is it enough to address everything? No. I think any township supervisor will tell you the fee they're going to get in most circumstances isn't going to pay much more than a mile of road, but at least does allow them to address some of the specific impacts. Water supply is a whole separate issue, and water remediation is a whole separate issue, and that's a transaction between the producer and DEP, and it makes it very specifically the financial responsibility of the producer to assure the safety of the water supply or to correct it if they cause damage. And that's completely separate from the local impact fee.
Okay. Steve?
Steve Allison, Fairbanks Township. You were talking about the fees, or could you give us an estimate, approximately what the fees will be collected, how much that amount is? I know there's been various studies, and each one's a little bit different, but
Right.
From the information you have, what kind of
Well, here's the issue. Because it is a county option, to the extent, most of the estimates that you see presume all the counties have adopted it because it goes into a central fund and then gets distributed back out. And so, for example, Bradford County is one county where it's been highly contentious. Bradford County currently has a quarter of the wells in the state. They have I think, approaching 2,000 wells in their county. And so if they chose not to adopt it, the overall collection would be reduced by a quarter of what's anticipated. Right now they're anticipating, depending on whose estimate you use, $190 to $210 million statewide. Okay? So that will affect it to a degree. But once the formula is in place, all I can tell you is if you take $50,000 per well if you're an impacted municipality, you can do a very rough calculation that a certain percentage comes off the top for statewide funds, and then you reduce that down 36% of 60%, and that gets you in the ballpark of what you might be likely to receive. I know the Township Supervisors Association is working through the data. I don't know how many counties they've completed estimates for now, but you can get in touch with them, and they might have a little better number for you. Part of the reason it's been difficult for them, they didn't have the entirety of the database to do the calculations, and particularly that one piece I mentioned, municipalities within 5 miles of a well, that kind of will skew the number a little bit, but at least they can give you a rough order of what it might be.
Okay, and some of the state agencies are getting a substantial amount of money there too. The DEP is getting, what, $5 million?
Something like that, yeah.
And what was the Department of Transportation?
Department of Transportation is $900,000.
Okay, there was several.
And there's of the money off the top. The other piece that comes out of the state 40%. 25% of that is allocated toward at-risk bridges. PennDOT gets none of that. It's administered by PennDOT, but every penny of it goes back out to all the counties in the state.
Because
and that money is available for county or municipal bridges.
Okay. when we go to the urban areas, how much money will they be getting? I mean, like your cities, or around the cities, because you said even if they weren't on host county.
Right.
And the formula is based upon population and mileage, right?
Well, no, there's two different formulas. On the state share money, the pieces come out of the 40%. The 25% that goes to highways and the 15% that goes to parks, open space preservation, and so on. Those are distributed based on raw population, but the minimum on the transportation side is $40,000 per county. The minimum on the parks and recreation side is, I'd have to look to be certain, but I think it's 25,000. Might be 15, but I think it's 25. The bottom line is, yes, there are some areas that will get more because they're larger, but the floor diminishes that considerably. And the other state funds, some go to state agencies, others go into competitive grant funds, so they're available statewide. There's also a program for vehicle fleet conversion. I think $10 million the first year, $7.5 the second, and $3 million the third. So if you have a fleet of 5 vehicles, you can apply for money out of that. So there are a number of other things that are available statewide.
Okay. Keith Etzel?
Yeah, Keith Etzel, Elk Township. The amount of wells that we have in Clarion County now, how much money do we stand to gain from those wells that's already, do you have any kind of figures like that, Greg?
I think
It's all speculative
it's
right
speculative,
now.
but I
because-
think if you go on the site, if I could, you had a sheet, about 150,000,
Okay.
if you have that sheet.
Yeah, I got a frac tracker printout here.
I mean, I think it can go up to 200,000, but I think the estimate in the colored shaded, it's hard to tell the two colors of what, but what I've looked at, it looks around 150,000.
Yeah. Okay, now my next question is, if you guys don't pass this and the municipalities do you still get a share of it?
No, not until they do their own separate enactment.
And the other thing is, if year one, we don't enact it, and 10 municipalities do, they share in that. Then the second year, we go, you know what? We need to be a part of this. It's only on the wells that were spud during that previous 12-month period. Where if you go in the first year, it goes back to all non-conventional wells and comes forward. Second year, if you enact it, you only get it off the wells that came during the second year. So it's...
But you'll be getting the second year fee from those other wells that have been
No,
included in the fee.
no, you will not the county won't.
Well, I'll correct you on that.
Yeah, they will. The county will get the second.
You'll get the second year fee, not the
Yeah,
first year.
but-
You don't recover the money that you missed.
And the first year's the big
prior
one.
enactment.
Well, yeah, because
With the amount of debt Clarion County's in, I would sure hope you guys do enact this.
Okay. Back-to-back Keiths. Keith Alman?
Keith Allman, Limestone Township. It seems to me that the counties are getting blackmailed into approving this, and only given 60 days to decide. I know when you accept this offer in the next 60 days, I usually think no thanks. The governor got $1.6 million for his campaign. You guys ought to at least be getting that much, and you don't even know how much you're getting. Yet they want you to opt in on this and be co-opted by this awful law. And I have an analogy that might clear this all up. This gentleman goes in to see his pastor, and he said, I'm getting audited by the IRS, and I don't know what to wear. And he said he talked to his lawyer, and his lawyer said, wear a three-piece suit, look professional. And then he said he talked to his accountant. He said, no, you go looking shabby. He said, they don't think you have any money. And the pastor said, well, this reminds me of a young lady that was just in here. She was going to get married, and she didn't know what to wear on her wedding night. And she talked to her mother, and her mother said, oh, you wear a full-length gown, lots of buttons clear up to here. And she talked to her girlfriends, and they said, oh, no, Victoria's Secret, skimpy panties and all that.
Are you going to keep this clean?
And he said,
Go ahead.
I'm finishing up here. And he said, Well, I'll give you the same advice I gave her. Doesn't matter, wear anything you want. Either way, you're going to get screwed. And I thank you, gentlemen, for having this. I think it was good of you to do this. It's a wise decision.
Okay, who's next? Anybody besides Mick, since you're on the right? Bill Fiskus has his hand up.
Bill Fiskus, Limestone Township. If the county doesn't adopt an ordinance for the impact fee, then my understanding is, 50% of the townships within the county must adopt it. Is this correct?
50%, or enough municipalities that have 50% of the population.
Okay.
Either way.
So, well, that's going to be interesting.
Make the whole county do it, yeah.
And if the county doesn't adopt and the townships do, then the county gets nothing on the funding.
That's correct. Until
The municipalities still would, but not the.
Yeah, the municipalities would still get the funding.
Until the county takes its own action later.
The county, so I kind of think it's a no-brainer. I'm not in favor of it, but by the same token, we're going to have to do something. Because I know in Limestone, we've already got one well, and there's a good chance we have another one coming. We're going to get impacted, no question about it. And we're going to need money. For what? The roads pretty well take care of themselves. I'm afraid of other items. Well, thank you.
Okay.
Well, on the gentleman's point, there is a cap for municipalities in terms of what they can receive. It is the greater of half of your budget or $500,000.
And now is that same cap on the county as well?
No. Well, but on the other hand,
I want to go, Mick, I want to go to new people, and then if we have time, we'll go back.
I would like to comment, though. I did ask questions before, but I would like a chance to comment before you.
Okay. Gentleman here. What's your name, Chris?
Thank you. I have an anecdotal
Can we get your name, sir?
My name is Chris Gemmel, and I am a co-owner of Lavender Green Farm in Beaver Township, Knox, Pennsylvania, with my wife, Jenna, who is here this evening as well. And good evening. I'd like to thank the commissioners for providing us with this opportunity and this public forum to share our perspective on the creation of a Marcellus Shale gas well impact safety net fee for Clarion County. We strongly encourage the commissioners to move in favor of establishing a set-aside funding under the recently enacted gas well impact legislation initiative, State Bill 1950, at the maximum level. The importance of providing this critical economic safety net for property owners of Clarion County cannot be overstated. Clarion County situates within the region that has been identified as among the nation's key epicenters for Marcellus shale drilling. Notwithstanding the adherence to best practices and a well-meaning commitment to environmental health and safety measures, the limited degree of industry regulation and oversight insists that local authorities ensure vigilance in the maintenance and preservation of the quality of life to which Clarion County residents have heretofore been guaranteed and are also guaranteed under the Commonwealth of Pennsylvania Constitution. These monies should be earmarked for schools, infrastructure, cleanup funds, etc. Fee assessment will not deter the Marcellus shale drillers who will, regardless, continue oil and gas exploration because such fee impacts will simply become integrated as a cost of doing business line item expenditure. Our request for favorable consideration of the maximum permissible gas well impact fee is based upon recent experience. On December 12, 2011, Lavender Green Farm sustained a catastrophic and simultaneous loss of performance of its natural gas and water wells. Referred to as a Speechley well, our natural gas well was created in 1982. Operating at a depth of 2,178 feet, the well recorded a top pressure of 80 pounds in late summer 2011. 4 months later, on December 12, 2011, the meter reading disclosed a top pressure of 1.5 pounds. Several well tenders, including, and some of you will know these people, Randy Larkin and Dick Forrest, both of whom are Clarion County residents, as well as technicians from UGI Central Penn Gas were consulted. Mr. Larkin in particular services more than 45 private residential natural gas wells in Clarion County. He reported that in his 40-plus years of well tending, he had never witnessed such a total and complete collapse of natural gas flow from a well that had 4 months earlier performed robustly. He noted that in the context of a well's lifespan, our 29-year-old well was considered very young. He is presently servicing wells in Clarion County that have remained intact and productive for more than 90 years. As for our water well, through the efforts of two technicians from Gatesman Plumbing and Heating, performance of the water well was reinstated following a comprehensive overhauling of the well shaft, intake valve, casing, and pump. However, a bailing of this well in the next summer will be required to address residual performance issues. In addition to the ongoing problem being resolved by Mr. Larkin, we recently consulted several additional authorities regarding the circumstance of our natural gas well. Dr. Bruce Dixon, who is a chief scientist with Applied Geology and Environmental Services, in collaboration with an expert authority in the oil and gas industry in Houston, Texas, reported to us following their review, quote, that seismic work caused a shallow problem in the gas well and the fill came in at a shallow depth, creating a sand bridge which is now plugging the well. Later in their remarks, in commenting upon the simultaneous damage incurred by our water well, they noted, in Texas, the seismic company is supposed to test landowners' water wells up to 3 times as necessary. A good company will test before and then after logging if the landowner sees changes. If the shock waves, as logged on the data, are above the amount allowed by the U.S. Bureau of Mines, the seismic company is responsible for the damages.
Okay, Chris, you've gone way over.
All right.
Hate to cut you off.
I will give a copy of my remarks.
Impact fee.
Thank you.
Impact fee.
Thank you.
For or against?
We're very much in favor of it.
Okay,
Absolutely.
that's what I thought.
More of it.
All right, yeah.
More money.
All right, who's
More
next?
money.
Yeah.
Okay, I don't see anybody new. Did you want to stand again?
I do. I just have some concerns about the Act 13 and the impact fee that I would like to share with you, just so that you do consider them. One of the concerns I have is the ability of these agencies to really oversee and monitor. And I hope, looking at some of the websites, when you've seen some of the inconsistencies in the data that you've come across, that maybe that's giving you some concern too, and maybe some impetus into getting some local oversight involved in this process. The other concern that I have is that I think it's pretty clear by the way this act was structured that the local governments are getting bullied, and that concerns me. I think we're losing our ability to protect the health, safety, and welfare of our citizens. And I think that's a real concern, and I hope that's one that you will consider as well. I know you don't have a lot of choice in this act. You know, the strictures on doctors and the regulations on zoning are going to come into effect whether you adopt the fee or not. The other concern I have is that if this impact fee gets rooted and gets set in place across the Commonwealth, that any chance of the people of the Commonwealth actually getting a fair share out of this, the natural resources in the Commonwealth, are going to go out the window. Okay. Now, when I've talked to others about a severance fee in the past, I mean, a lot of what I've heard is, oh, that's socialism. But look at what's happened in the state of Alaska. Not only does Alaska have no income tax, they have no sales tax, they actually give a dividend back to their residents from the fees they're getting from the energy that's developed there. Okay? I think Pennsylvania's going to lose their chance to do that if this fee gets rooted, because nothing's going to come in and take its place, quite frankly. This is going to be it. This is the chance that we have. I would strongly suggest to the commissioners that you consider the concerns very seriously. And I would ask that you take a stand on principle and don't enact this fee for the county. And just to let the General Assembly know that there are concerns that local government has, that they have for the protection of their citizens and for a fair shake for the citizens of Pennsylvania. Thank you.
Okay, is there anyone else? Yes, ma'am.
I just wanted to know what your reasons would be for not participating in this program. All three of you. I mean, you asked us our opinion on that.
We're not. Coming into tonight's meeting, I was leaning very strongly for enacting it because having been in Harrisburg, having read it, it's pretty much, as several of you have said, that we're being bullied into it. But where do we draw the line? Do we want no money, stand on principle, and suffer the consequences of the drillers and everything that goes on? Or do we take the money and try to make it as best we can and do the best job possible? A little bit more money is going to make it a little bit easier to push DEP, the other regulatory agencies, to get more oversight, stronger oversight. So I personally, coming into this meeting, was leaning towards it, and I am now leaning more towards it because it appears that the majority of the citizens here are leaning that way. That's where I'm at.
Okay. We'll get to you, sir. Hold on, we're not done yet answering her question, but we'll get to you next, okay? Because he hasn't spoken yet. I'm looking for the feedback from you folks and supervisors. Because if I feel that the supervisors are going to enact it anyways, because we don't, then why shouldn't we? And then there's the whole economic development situation too. We've heard a lot of people that are concerned about economic development and this perhaps hindering that. I'm not so sure that $50,000 is going to hinder a gas company from drilling, but that was another situation. So that's basically where I'm standing right now.
No firm stand one way or the other.
Not at this point.
We're just going to kind of go with the